Hello everyone, I'm Nazarat Fatima. Welcome to LiveLaw. The Rajasthan High Court was hearing a plea against the order of an Udaipur court, which had rejected a man's plea to amend the divorce pleading on the basis of DNA paternity test of the son. In his plea in the family court, he had claimed the same to be a subsequent development. Later, he submitted that the DNA paternity test report revealed that he is not the father of the child. The High Court rejected his petition to bring on record his alleged son's paternity test, which resulted in the divorce case pending before the family court. Regarding this case, the Rajasthan High Court observed that the child cannot be used as a weapon to get divorce on grounds of adultery. The court said that DNA test invades upon the rights of the child and it may affect the child's property rights, right to lead a dignified life, right to privacy, and right to have the confidence, and he'll also be deprived of the happiness of being showered with love and affection by both the parents. Justice Dr. Pushpender Singh Bhati observed, and I quote, "The DNA paternity test requires to be conducted only in exceptional cases, and therefore the child cannot be used as a weapon to get divorce on grounds of adultery on the strength of the outcome of a DNA paternity test." The court said it is necessary for the man to first prove that he had no excess with his wife, and only thereafter the benefits of exceptional exclusion from the purview of Section 112 of the Indian Evidence Act 1872 can be extended to the aggrieved party. Justice Bhati said that the court has to take into consideration the mental and physical health of a child and the aspects adversely affecting it. The court highlighted the importance of children and how the matrimonial disputes affect their lives in adverse ways. It said, and I quote, "It is high time that the society and law realize the importance of the child and childhood vis-a-vis the matrimonial disputes, as losing and winning in a marriage is having a dwarfed impact when it is compared with losing of childhood in terms of victimizing the child or sacrificing his constitutional right of dignity at the altar of matrimonial conflicts." The court also said that this issue has to be seen through the prism of the child and not through the prism of the cantankerously fighting parents. It observed that a child cannot be used as a pawn in the divorce litigation, where either of the parents want to get rid of the spouse while sacrificing the crucial rights of the child to a dignified parenthood. The court, while laying emphasis on the life of a child, said that using him in the divorce litigation in such a way will not only cause an unfathomable misery upon the rights of the child, but will also create a permanent dent on his existence and psyche. The court said that it will affect the mental health of the child and its impact will stay for the rest of his life. It added, and I quote, "The pain of winning or losing a battle of divorce amongst the contesting spouses is much trivial when compared with the rights of the child to have dignity and parenthood." The court noted that the husband had filed an application under Section 13 of the Hindu Marriage Act 1955, in which there was no allegation of adultery. It added that the divorce application was filed by the husband in 2019 without taking any ground of adultery, but merely by mentioning the wife used to tell him that he is not the father of the child. It noted that the marriage between the parties was solemnized in 2010 and the boy was born in 2018. The wife left the husband's house in 2019. It also noted that the DNA paternity test of the child was conducted in 2019 without taking the child or his mother into confidence. The court observed, and I quote, "The record of this case clearly reveals that the petitioner husband and the respondent wife were living together at the time of birth of the child, and thus the husband was having access for cohabitation. Thus the question regarding presumption under Section 112 of the Indian Evidence Act does not even arise in the present case." The court referred to the apex court's decision in Aparna Ajinkya Firodia versus Ajinkya Arun Firodia, wherein it was observed that the family courts have power to order for DNA test, but it should not be directed in a routine manner without any justifiable reason for the same. The same should be done after duly complying with the principles of natural justice. The husband thus cannot take undue advantage of the DNA test so as to shrink away from his obligation. It also observed that any matrimonial dispute between the husband and wife relating to the child born from the wedlock cannot be used for their own benefit by way of DNA paternity test, among other things. Justice Bhati said, and I quote, This court is quite conscious of the fact that any frivolous claim of the husband or wife would have much adverse effect on the mental health of the child, though the husband has a right to prove adultery on the strength of cogent evidence against his wife. Considering the fact that a child's life and overall mental health will be adversely affected by it, the court said, while choosing between the sanctity of marriage and sanctity of the childhood, the court has no option but to tilt towards the sanctity of the life, that is, tilting towards the sanctity of the childhood. The parties may or may not lose the marriage, but the spirit of justice cannot afford to lose the child or childhood, as no court can shut its eyes so as only to achieve the goal of justice and matrimonial redressals while losing the battle of parenthood, being detrimental to the childhood. As such, while making these observations, the court refused to grant any relief to the man. That's all about it for today. We hope you like our content. If you do, please like and share our videos. Also subscribe to our channel on YouTube. And don't forget to press the bell icon for notifications. Thank you for watching.